Welcome to Employment Law. My name is Reshma Devasari and I'm the module convener for this course. I'm really happy that you chose Employment Law as your optional module. I love the subject area. I practiced civil litigation for about 10 years, and a large part of that was employment law, including in particular issues about discrimination law and equality law. So I think it's a very exciting and interesting topic, and I love teaching it. So I hope we'll both enjoy ourselves through this process. And let's just get started today with the introductory session and what to expect. Everything that you need to know about the course is, of course, on Moodle. So I'd encourage you to scroll through that and you'll see the kinds of topics that we're going to cover. But the purpose of this lecture is to go through course content, course structure, and introduce you to some very elementary, basic employment law concepts. And I'm also going to touch on what the assessment will be. For those of you who are watching this who are taking the course from the business school, there will be some changes. It's not going to be the exact same setup, but I'll talk to you about that separately. So the first thing I should point out is that, and you're all year 3, so I'm sure you're quite familiar with Moodle, is that you just need to scroll down and you'll see under each week the PowerPoint slides that are there for you to have a look at. And then there'll be a link to YouTube or wherever where there's the video. So let's get started. And you can follow along with the PowerPoint slides if you'd like. So the first reason why I think employment law is extremely interesting and hopefully is a subject that will retain your interest throughout the duration of the course is because it's a very common sense kind of topic. For those of you who work yourselves, you'll find out about your rights as an employee and what responsibilities your employers have towards you. For those of you who aspire to become human resource professionals, then obviously this is an indispensable course, but it's also important for business managers or entrepreneurs so that they know what their legal obligations are towards their staff if they are to set up businesses. So what's very important to remember throughout employment law is that it's a weave of ordinary and basic contractual law principles that you would have learned in years 1 and 2. And that is woven in with special statutes that were specifically designed to address issues that arise very commonly in the workplace, and also to tackle discrimination in public bodies and in the work sphere. So it's the usual contract law principles with an extra layer of specific employment law statutes to deal with issues. So for this session, let's look at the content, structure, and assessment in this module. We'll look at what areas employment law actually covers, and we'll look at the sources of employment law. Now, what does that mean, sources? What that means is where to look for those rights or obligations that I just touched upon. So which statute do you look at? And how is it broken up? What sections would you go to look for specific things? That's what sources of employment law mean. And we'll also look at some basic concepts today. So the way the course has been set up is that we cover topics that are very practical, that are from a human resource-led perspective, and that are that will allow you to develop the skills that are required to tackle very common problems that arise in a working relationship, and that are the most common ones to employment. So it's the main day-to-day issues that affect the employment relationship that we're going to look at, and skills are interwoven into the course so that we develop and refine your skills like problem solving, critical thinking, and writing skills. And we'll also look at some of the very topical and evolving issues, particularly in respect of COVID and a lot of changes to employment that has occurred recently. The course is structured over a 10-week period with no breaks or interruptions, which means that we have 10 lecture sessions, which will be largely recorded, like this one, and then we have 9 workshops. The assessment is in 2 parts, and this is for law school students only, not those of you in the business school, but the assessment is a coursework. It's a problem question of 2,000 words. We use the IRAC style to tackle coursework questions, and I'll refresh your memories on that. And that is submitted tentatively, you'll see, the week commencing the 14th of December. And then we'll have an adjusted exam. Again, their tentative dates in January, but that's decided centrally by the university. But what I can tell you is that the exam will be completely multiple choice. The coursework forms 60% of the mark, and the MCQ test, which is about an hour, forms 40. Hopefully you'll recall that when tackling essay questions, but particularly problem questions, which is the one set for this coursework, you need to use this IRAC style, which I've put up here for you. You might want to print this out, this slide, and tack it on your wall or something, but you need to identify the issues, or all of them, when you're looking at a question. Identify what the relevant law is. And what does that mean, the relevant law? That means the statute that applies. What statute applies? Or there might be more than one. And what's the case law? Because, of course, you know that it's also a mix of common law and case law. So what are the leading cases? That's what the law is. That's what that second line means, relevant law. Identifying which statutes apply and what case law applies. You then, as a third step, apply the law that you just identified to the facts presented in the scenario. And each fact that is included in a problem question is always there for a reason. It's in order to prompt you to jog your memory about a particular issue, or prompt you to answer in a particular way, or extra facts are put in order for you to discount or be able to eliminate certain things. So do look at the facts carefully, their reason why they're there. And then, of course, the last part is your conclusion, or what advice you would be giving your client or your friend or the HR manager or whoever it is. And that advice should be clear and concise. So that's just a quick run through to jog your memories about the style that we use in the law school, which you should all be familiar with. The learning outcomes for this session is, first of all, so that you appreciate the inner relationship between how contract law and employment law and other legal issues overlap with each other, to understand where, or begin to understand where you can find sources of employment law, what areas are covered, and to learn about some basic and fundamental concepts. So obviously, employment law is concerned with the legal issues that arise in a relationship between the employer and the employee. That's quite obvious. However, employment law can also cover other people who might be engaged in carrying out services where they are not defined as employees, but for certain purposes might be workers rather than employees. And then there's another issue about people being self-employed and whether they're truly self-employed or not. That's session 2, which we'll look at. But I just wanted to show you that this definition about employment law covering issues arising from the relationship between employer and employee is not always so straightforward. Sometimes the person is not the person who's rendering their services. It's not an employee. So it's this bottom part that sometimes we need to also think about. But moving on, when you think about what issues employment law covers, it's helpful to look at it in a very logical way by looking at a common recruitment process. So somebody applies for a job and then all the way through the so hiring people, the entire recruitment process to the interview itself, where they shouldn't be discriminated against for any of their protected characteristics, so because of their gender or their sexual orientation, etc. The advertising for the job should also be non-discriminatory. A lot of people don't realize that even advertisements do fall within employment law. All the new joining formalities when an employee does get the job, so the handbook, the company's policies, procedures, the grievance procedures, any negotiation about the person's remuneration, their bonuses, promotions, whether they'll be moved or can be moved from one company or area to another, and including all of their benefits. There might be restructuring within a company, where one company takes over another and the employees are moved across. That's called transfer of undertakings, 2P. That's covered. And of course, everything to do with the employee leaving the employment situation. So they might leave of their own accord. They might be fired, which is called dismissal. Or they might agree to some kind of settlement agreement to be able to get payment in order for not raising a claim that they might otherwise have. So they don't take a case to the tribunal, but instead they settle for a particular amount of money and go away quietly. Employment law covers references. So after the employee has left and is looking for work elsewhere, it's often part of the new employer's recruitment process to get a reference and also to find out about their illness record or absence record. So that might be negotiated. That also falls under employment law. And as I touched on before, everything that has to do with the Equality Act 2010, which I'm sure many of you have heard of, but the protected characteristics and essentially people not being discriminated against because of their race or ethnicity, gender, sexual orientation, etc. And it includes harassment, particularly sexual harassment and victimization. And obviously employment law covers aspects of litigation, which we'll touch upon just a little bit so that you understand how procedurally that works. So it's a very, very wide a scope that's covered in employment law, and one that is, at least to me, extremely interesting, and I hope you enjoy it as well. So you'll see from what I ran through, we'll look at employment status. That means whether a person is an employee, a worker, or self-employed. We'll look at dismissals, which is firing someone. What happens with redundancy, so there's simply no work for that person anymore in that company or that particular job that they're doing. What are the special rights that the employee has, what are the obligations that the employer has when they're looking at redundancy, discrimination law, family rights, equal pay provisions, and whistleblowing. So these are the main topics that will be covered. Please look on Moodle for all of these. They go weekly. Don't skip ahead, but do have a look through your textbook and Moodle to see what topics we're covering. So perhaps you can tab them up, either the actual physical textbook or electronically, so that you're a little bit organized. So now that we've looked at what the course content is and the structure of it and the assessments, let's actually start by looking a little bit more in detail. So the first time there was really a comprehensive regulatory framework that was made to cover all aspects of employment law was in 1971, which is fairly recently. Before that, everything had to be dealt with the courts under the common law system, and there were no special protections or provisions. And there was also no concept of fairness, of an employee being treated fairly. Basically, employers were free to do whatever they liked as per the contract. And the whole concept of behaving in a way that's fair towards employees came about, as I say, relatively recently. There were particular statutes and case law that have been developed to interpret the statutes and to also look at the concept of reasonableness, because the main difference between ordinary contractual principles and employment law is that it's presumed in contract law that the parties are at equal bargaining power. They can equally, both of them, negotiate with each other to come up with terms and conditions that are acceptable to both parties. Now, that's not the same in an employment relationship. The employer always will be in a stronger position, and it's very limited. The amount that an employee can actually negotiate things is relatively limited. And that is why these concepts of fairness and reasonableness came up to address this. So just going back to your year one, year two traditional contract law concepts about offer and acceptance and intention to create legal relationships, etc., for forming a contract, it's slightly different, as I already touched upon, with employment law, because of there being an acknowledgement that there isn't really equal bargaining power between the parties, and that the employee still is subservient to the employer. All right? So there's a very famous quote by Lord Stein, which I'll let you read, but it's really about getting the balance right between the employer's interests and an employee not being exploited. So in employment law, there are no requirements for any particular formalities or forms for the contract of employment to exist, and that's by virtue of Section 230, subsection 2 of the Employment Rights Act 1996. Employment contracts can be expressed or implied. They can be oral or in writing, and you'll see that this is very different from land law, where there are formalities. Land has to be done via deed. Only then there's a contract. Not the case in employment law. So, as I said, there are contractual terms on both sides that are often implied into the contract. Some are expressed, so they're specifically set out in statute, and some are implied duties, and they're on both sides. So looking at that of the employee, there's obviously a duty to exercise reasonable care and skill when they carry out their work. They need to obey lawful orders of management. They should be loyal to their employer, which means, for example, they shouldn't be working for a competitor or giving out confidential information. And employers have a duty to obviously pay wages, maintain the health and safety of the premises and of their workers. They have unusually, a lot of students think, an actual positive duty to provide work. And there are other contractual terms, like I said, that might be in a handbook, which, depending on the force of those policies, it depends whether they'll be expressly incorporated into the employment contract or not. But the very important statutory provisions for you to look at is the Employment Rights Act 1996 that deals with, I'd say, about 80% of the course will be found in the sections of that act, and then everything to do with discrimination is in the Equality Act. Then, of course, we have a lot of EU directives and regulations because the EU has changed to a very significant extent the way in which employment law, domestic employment law here in the UK has been interpreted. And they're far more generous in Europe. So these are the main statutory provisions. So you'll see that modern employment law is really a hybrid between contractual principles and the statute. And that's a very famous quote by Lord Justice Sedgley in the Bournemouth University case, which I'll leave you to read. In terms of the protection that is afforded to people, you can imagine, and you probably already understand by your own personal experiences, that there's the individual level of regulation. So that's between the employee and the employer. And these are when both parties voluntarily enter into a legally binding agreement. And then there's the collective level also, which is of course much, much larger. That's when trade unions or employers associations, etc., those kind of bodies come together to collectively negotiate terms or changes for their body, for their members. The main sources I've touched on, the statutes there. Case law, it's important to pause here so that you understand clearly that for employment law, we are looking mainly at employment tribunal decisions, but in particular EAT decisions, which is the Employment Appeal Tribunal. It's only the Employment Appeals Tribunal decisions that are binding upon the Employment Tribunal. So you have the Employment Tribunal at the bottom, and it's the Appeal Tribunal whose decisions are binding upon the lower court. We have lots of codes of practice that are not legally binding, but are extremely important and shouldn't be overlooked at all, because if matters do go to court, the courts will look at the guidance, and if the guidance hasn't been followed properly by the employer, they oftentimes will give an uplift, give additional money, additional award of damages to the employee. So, if the employee wins his or her case and can also prove that the employer didn't follow the codes of practice, they'll get even more money. So it's very important to be familiar with those codes of practice, and I'll obviously show you where they can be found. We also have High Court and County Court cases, because for clear breach of contract matters, the people have a choice of whether they want to issue proceedings, means sue in the employment tribunal, or whether they want to sue, depending on the amount of money involved, in the county court or the high court. And also, civil courts can grant injunctions. So, for example, restraint of trade. So if somebody, an employee has left a company, taken clients with them, so sort of poached them, and then has set up their own business someplace else, the employer might want to, or the last employer might want to stop that ex-employee from doing what they are doing. So they will get an injunction. So to get an injunction, they would go to a civil court. I touched on the codes of practice. The first body, and perhaps the most important one, is called ACAS for short. It's the Advisory, Conciliatory and Arbitration Service. That's quite a mouthful, but it's ACAS for short. And it's their guidelines that are very important to be followed. It's simply an organization that was set up to improve the working life of employees and to facilitate good industrial relations and practices. So they publish various codes of practice about grievance procedures and things like that, how the internal HR department of various companies should handle things. As I mentioned, tribunals can uplift compensation if they haven't been followed. If someone wants to issue proceedings before those pleadings go to the court, it sits with ACAS, and ACAS has to try to talk to both parties, that's the employee and the employer, and see whether or not they can negotiate something or compromise and solve the issue between them. It's only if both parties say, or at least one party says that they are not happy to settle, that the matter actually goes to court. So it's mandatory to go through the ACAS process before issuing proceedings. Very similar to family law. If any of you have taken family law about divorce, the procedure that has to be done before issuing the decree nisi. The second organization that you need to become really very familiar with is the Equality and Human Rights Commission. You hopefully would have heard of them, but basically it's a commission that's responsible for the promotion and enforcement of non-discrimination laws. So everything that's set out in the Equality Act 2010. They'll often fund, meaning pay for, litigation if it's if they deem it to be in the public interest. So a wheelchair user, for example, asks their employer to put up ramps and change the building around so that they could move around freely in the office, and the employer refused, for example. Just giving an example off the top of my head. And if that person were to go to the commission and say, well, this has really serious public interest for people other than just myself, these issues are important. I think probably something like race discrimination might be a better example. Then the Equality and Human Rights Commission might actually help fund the suit, the claim, because they want laws to develop and case laws to develop to stop discriminatory acts by employers. They also, like ACAS, published guidelines on discrimination law, how to avoid it in public and employment sectors. So please become familiar, perhaps go on the ACAS website. I would go on the ACAS website and just look through scroll through and familiarize yourself with ACAS. You can get a flavor for how they approach things, and also look on the Equality and Human Rights Commission's website as well, please. It will really help you just spending 10 or 15 minutes on each website. There's then the Central Arbitration Committee, which is outside of the court system, which I explained a moment ago about the Employment Tribunal and Employment Appeals Tribunal. So you have a arbitration committee, and they basically adjudicate on issues, and it's generally the large trade unions that go there to bring claims that involve people on a collective level. So you might see some decisions that have come out from the Central Arbitration Committee. The Information Commissioner, you would have all heard of. It was established after the Data Protection Act came into force, and it's to prosecute persons who are offending the relevant legislation. So employment laws, just to recap, they regulate the relationship between the employer and employee. And that is, of course, the basis upon which labor and money are exchanged, and how the whole economy ticks. So the laws, and this particularly the Employment Rights Act 1996, tries to redress any imbalance or abuse in the relationship, and employment law intervenes to make agreements fair where they are otherwise deemed not to be very fair. So that was a whirlwind tour of employment law. I can understand that there's a lot for you to take in, but it's really a fascinating subject. As I said, I love it, and I hope you'll enjoy it also. If you have any questions, of course, please feel free to email me. You have my address. It's reshma.devasari@theusualroehampton.ac.uk address. Okay, bye for now. Thank you very much. Bye-bye.